Good morning, everyone. Nice to see you. Happy to be here today with my colleague, Minister Nally from Service Alberta and Red Tape Reduction to talk about proposed changes to Alberta's FOIP legislation. I will start with some background information and details about privacy policy, and Minister Nally will follow up with access to information policy. Today, the Government of Alberta is taking a significant step forward to strengthen and modernize its access to information and protection of privacy legislation. Alberta is committed to protecting the privacy of Albertans, and Alberta's FOIP Act is out of date and overdue for an update to better reflect modern times. In 2019, privacy commissioners across the country called on every provincial government in this country to update their privacy legislation, and today we will share with you our next steps to make that happen. The first change is that we will split the FOIP Act into two separate pieces of legislation. One exclusively for privacy, and one for access to information. And let me tell you why this is important. Our privacy legislation has not seen meaningful updates in over 20 years. This means that our privacy legislation predates modern technologies like social media, mobile phones, and yes, even the internet. One of the reasons why our privacy legislation has not been updated in such a long time is because every time the government looked at it, they had to look at both the privacy provisions and the access to information provisions at the same time. And getting consensus among all those affected by these policies was much more difficult than if we could just look at privacy or just at access to information. So, by splitting FOIP into two acts, we can ensure that as technology continues to evolve, and if amendments are required to strengthen our privacy protections for Albertans, we can be more nimble and focus exclusively on privacy, and vice versa with access to information. So, let me talk a bit about our plans for privacy protections. Alberta intends to implement the strongest privacy protections and the strictest penalties for privacy violations in all of Canada. Every day, Albertans interact with government services. Every day, patients see doctors and nurses, or surgeons and specialists. And every day, Albertans visit motor vehicle registries to register a vehicle or renew a driver's license or book a driver's exam. Every day, Albertans rely on the Land Titles Registry when they buy or sell a house. And every one of these interactions results in the creation of a record. Whether it be a paper record or a digital record, a record is kept. And another word for these records is data. Now, this data is essential for the delivery of services. Without that data, physicians wouldn't know a patient's medical history to inform a diagnosis. And without that data, Albertans couldn't purchase a home with the confidence of knowing that the title is free and clear of all encumbrances. Without that data, a driver wouldn't be able to secure a loan for the purchase of their next car. The things we take for granted in our daily lives are dependent on these records being kept. The Government of Alberta is the steward of this data on behalf of all Albertans, and it is our job to ensure this data is accurate, collected with proper authorization, protected from unauthorized access and disclosure, and used for legitimate purposes for the benefit of Albertans. And so earlier this year, I shared with you my plan to launch a series of initiatives to enhance transparency and to strengthen privacy protections for Albertans. We started with the launch of Alberta's Privacy Management Framework and Data Ethics Framework in January of this year. And today, we take the next step towards implementing the strongest privacy protections in Canada. Bill 33, the Protection of Privacy Act, replaces and augments the privacy protections previously contained in the FOIP Act. This legislation applies to the Government of Alberta and to all public bodies in Alberta. This legislation makes it law that the government will never sell your data. No government ever should, and thanks to Bill 33, no government ever will. We are also introducing mandatory breach notification so that you must be notified in the event of a privacy breach, resulting in a risk of significant harm. We think you should know when that happens. In today's fast-moving technology landscape, artificial intelligence is a tool that is boosting productivity and automating processes in every industry and also in government. We believe that if AI is being used to assist in content generation, decision-making, or predictions that affect you, then you deserve to know. This legislation will make sure that you know. This legislation also introduces the concept of non-personal data so that public bodies can anonymize or de-identify their records for the purpose of research and analysis. This will help to improve public service delivery while strengthening privacy protections for all Albertans. These amendments are a vital part of our plan to ensure that Albertans have the strongest privacy protections in Canada. And to accompany these protections, we are implementing the strictest penalties in Canada for those who violate our privacy laws. The strongest protections and the strictest penalties. This legislation is designed to give you more confidence and trust in how your government manages and uses data. I want you to have confidence that your personal information is protected at all times and is secure from unauthorized access. With that in mind, I do have one more initiative to share with you that I'm really excited about. You see, I didn't just want to strengthen our privacy legislation. I also want to give Albertans the ability to see when, how, and for what purpose their records are accessed. That is why we will be launching an online privacy portal to show you exactly that. We will even include a feature for you to automatically file a privacy complaint if you believe your information has been misused for any reason. At the initial launch, this portal will include information like our childcare digital service, vehicle registrations, and driver's license renewals. And we will continue to add more services to the privacy portal over time so that you and only you can keep tabs on your information. So stay tuned. We look forward to launching the privacy portal very soon. In closing, accurate records are an important foundation for high-quality government services. Whether it's your birth certificate, your driver's license, or your medical history, you deserve better, faster, and smarter services backed by the strongest privacy protections in Canada. The strongest privacy protections don't happen by accident. They happen by design, and that is what Bill 33 is all about. With that, I will now pass it off to my colleague, Minister Nally, to talk about access to information policies.
Good morning. Thank you. Thank you to Velvet Thunder, Echo Productions, the media, everybody else that came out today. I know there were some watch parties last night, so I wasn't sure what our attendance was going to look like. Now, as Minister Glubich indicated, updating Alberta's FOIP Act to align with modern realities is long overdue. The Freedom of Information and Protection of Privacy Act, or FOIP, came into force back in 1995. That was a time before the commercialization of the internet, before smartphones, cloud storage, and social media. Our digital environment has changed dramatically over the past few decades. The world has moved on, but our legislation has not. Albertans have made it clear that it's time to update these laws to align with today's realities. As our world has shifted from paper to digital, so have our expectations for access to information. We recognize that Albertans want a system that reflects these modern needs. Bill 34 will ensure that the definitions and processes for addressing public body records are more clear. This means a more straightforward, transparent, and responsive process for accessing public body records. The bill will address key issues around definitions, such as records to include electronic records, timelines for responding to requests, and the ability for public bodies to proactively release information. The ability to access government information is a key freedom that Albertans expect. The legislation will improve Albertans' ability to understand what, how, and when they can access government records. A key feature of this legislation is further empowering public bodies to proactively disclose information. In other words, Albertans will be able to receive more information without having to go through a lengthy access request process. The government of Alberta already proactively discloses a lot of government information, including ministerial office expenses, sole source contracts, and a variety of data sets and publications on the Open Government Portal. But existing legislation has not always been clear how that can be done while respecting the requirements in the Act. The new legislation will make it clear that public bodies can proactively disclose information outside of a formal FOIP request, subject to certain conditions such as ensuring records do not contain personal information. The Act will also better define cabinet confidentiality and streamline processes in a way that allows government officials to focus on good governance. Cabinet or committee records or information revealing deliberations of cabinet will be withheld. frank and robust discussions around the cabinet table are key to the decision-making process. Indeed, the Supreme Court of Canada has recognized cabinet confidentiality as being essential to good government. Records subject to solicitor-client privilege, such as a legal opinion pertinent to a potential policy, will also be withheld. Related to this, the proposed legislation makes it clear that the Information and Privacy Commissioner, or OIPC, cannot compel records that are subject to cabinet confidence or legal privilege. Only the courts can do that. That said, we also recognize the OIPC requires some assurance of transparency and good judgment. An attestation process will be outlined in regulation, will be provided to the OIPC to help the Commissioner to confirm that the exception was correctly applied. The legislation strikes the balance between Albertans' desire to quickly access government information and the confidentiality required to deliver good and effective governance to the people. With the Access to Information Act, the OIPC will have more latitude to require public bodies to address complaints and dismiss complaints that lack sufficient grounds. Currently, the OIPC must investigate every complaint that it receives, which is a drain on resources. On a different front, the Act will allow public bodies to extend processing timelines for access requests during emergencies without having to update legislation temporarily. This change will allow public bodies to focus on more urgent tasks related to emergency management and public safety, while still addressing access requests in a timely manner once the crisis has passed. Now let's take a quick look at what's happening in other jurisdictions. Alberta is not alone in making these legislative changes. In fact, we're somewhat late to the party. In 2019, a joint resolution from Information and Privacy Commissioners across Canada urged all provinces and territories to update their access and privacy legislation. Since then, all other provinces and territories have updated their laws except Alberta. Although access to information legislation varies from province to province, they're all built on the same principle of ensuring the public has a right of access to records in the custody or under the control of a public body, subject to specific and limited exceptions. Alberta's approach of a standalone access to information legislation sets us apart from other provincial governments. Today is a big step forward. The proposed act will protect Albertans' rights to information and the confidentiality that is required to ensure good decision-making and effective governance. While the introduction of this bill, we are doing more than catching up. With mandatory review in the Act every 6 years, we are setting the stage for the continued evolution of access to information in Alberta. This concludes my remarks for today. Thank you very much for coming.
Thank you, ministers. That brings us to the end of the formal portion of our news conference. We'll move on to the media question and answer portion. As a reminder to all reporters present or on the phone, we have the following people to respond to questions: Minister Dale Nally and Minister Nate Glubish. I'd like to remind everybody that we've got two very busy ministers here, so I'm just going to allow for one question and one follow-up. And I just ask media to identify yourself and your outlet and let us know who you are directing your question to. For media in the room, we'll start in the room and then go to the reporters on the line. Go ahead.
Hi, it's Janet French for the CBC. My first question is actually for Minister Glubish. So you keep bringing up this phrase, the strongest protections in all of Canada, biggest fines in all of Canada. There's a bit of a caveat there, right? Because it doesn't apply to the Health Information Act. It doesn't apply to PIPA, as far as we know, unless you've got some changes planned for them. And those are where we've seen some of the most egregious breaches of health information and private corporations releasing information. So I guess what other laws do you plan to amend to try and bring those in line with the standards that are now going to be applied to public bodies?
Yeah, thank you, Janet. So you're correct. In Alberta, we have three different types of privacy legislation. We have what was under FOIP, which will now be under this new legislation created under Bill 33, that affects public bodies, which includes the government of Alberta and all of the public bodies. And if you need details on what's included in that, we can give you a long list. But then we also have the Health Information Act, which applies to health records. That is under the stewardship of the health minister. And that has some very robust protections as well. And that is to make sure that we have the right information in the right hands at the right time to ensure the best possible care for every patient is delivered. The changes to date do not affect the Health Information Act, but one of our goals over time was to take this first step on FOIP because we had the time and the legislative schedule to do so. And then look at saying, how do we take further steps to continue strengthening all of the privacy protections afforded to Albertans. So we're starting with public bodies. We have the opportunity to look and say, are there some things we can do in the Health Information Act to make it even better? But that one's already very strong. And then we have PIPA, which is the private sector privacy legislation. So the difference being is with the public sector, the public body privacy legislation, that is you as a citizen when you interact with government or a public body, what are the rules that govern the information about you that are collected in those records, whether it be your driver's license, whether it be any of the things that I mentioned in my remarks. Then PIPA deals with if you as a citizen in Alberta are dealing with a business or a not-for-profit or a private enterprise, and through that interaction there are records created with information about you, the rules in PIPA outline what must be followed. And so there is currently a legislative committee looking at PIPA with the intent that they'll bring some recommendations forward to me to consider. And we have scheduled 2025 as the year that we would like to update and further strengthen PIPA. So as I said back in January when I launched the privacy management framework and the data ethics framework, that was my first step. This is my second step. The online privacy portal is a third step. A fourth step will be PIPA and potentially some consequential amendments in HIA if we believe that those are required in order to elevate our game. Our goal is indisputably strongest protections in the country, and I believe we are well on our way to making that happen.
But will the expectations and the penalties applying to the private sector be as stringent as what you're applying to the public sector?
Well, I don't want to prejudge the important work of a legislative committee that is doing that important work to analyze the private sector privacy legislation and to make recommendations. I look forward to receiving their recommendations. We'll do a lot of work in 2025 in consultation with that committee, as well as with stakeholders and industry and affected Albertans. And my intent would be to bring forward amendments to strengthen and modernize PIPA in 2025. And we'll have a whole lot more to say about that after we've done a bit more of that important work. Thank you, Janet.
Hello, Matthew with the Edmonton Journal. I just want to ask about Bill 34, Mr. Nally. It expands some exemptions on political staff. It looks like it might take longer to get responses back because we're talking business days instead of calendar days. It gives the option of proactive disclosure but doesn't make it mandatory, and it lengthens the appeal process. So I'm just hoping you can talk about the policy rationale here, because it looks like a lot of that's going to make it harder to get information and easier for government to keep stuff secret.
In fact, that's not true. What this is going to do is essentially modernize the legislation. Now, with respect to political staff, they've always existed. FOIP is about access to government records, not access to political conversations. So this is about government records, and we're simply modernizing it. And let's remember that the last time these amendments were released, you probably read about them on Windows 95. These came out before Google. So this is old and it needs to be modernized. That's all we're doing. We're just modernizing the amendments, and we're providing some clarity where it's lacking.
Okay, speaking of the Privacy Commissioner, she's investigating the province's FOIP system. It's scheduled to be done as soon as next month. Why not wait for the results of those, and will you commit to perhaps amending this based on her recommendations?
I can say that both technology and innovation, as well as Service Alberta and Red Tape Reduction, have consulted extensively with the OIPC, as we will continue to when we build these regulations, and we'll continue to take whatever feedback that she has.
Hi there, Jonathan Bradley, Western Standard. So the Alberta government has proposed to divide the Freedom of Information and Protection of Privacy Act into two acts. What steps will have to be taken to complete this division?
You want to take that one?
Well, essentially, that is what these two bills is all about. So these two bills will repeal FOIP, and then all of the components of FOIP that dealt with privacy will be embedded into the new privacy legislation created under Bill 33. All of the access to information provisions under FOIP will move into the new legislation created under Bill 34. But the fact is that all of the protections afforded to Albertans under the old legislation will move forward into these two separate acts. We already have all of the infrastructure to support it. And then the information we've shared in today's press conference about some of the amendments that strengthen privacy protection or modernize access to information, as Minister Nally talked about, will be embedded in, if appropriate, in Bill 33 for privacy, if appropriate, in Bill 34 for access to information.
Okay. The Access to Information Act would set clear timelines to the Office of the Information and Privacy Commissioner to complete reviews and respond to requests. What will those timelines look like?
They want to be 180 days for the Privacy Commissioner investigations.
Thank you.
Hi, Cindy Tran with the Edmonton Journal. This will be to Minister Glubish. In regards to the penalty increases, why are you going from $10,000 and jumping to $125,000? Is that not like quite a significant amount?
I would say, who do you care most about protecting? Do you care about protecting Albertans, or do you care about protecting government? In my mind, I think protecting Albertans is the most important thing. And at the end of the day, if there is an intentional violation of privacy legislation, the people who violated it should pay a heavy price.
And my next question is on the online privacy portal creation. You said that's coming soon. How soon is soon?
Well, I don't want to give you an exact date. We're working on the final details, but we're very, very close. And my hope would be in the next several months we should have the first version of that ready. But as I said in my remarks, our intention is to make this something that we can update continually until we have all of the records that are in the care and custody of the Government of Alberta and public bodies accessible to the public, so that an individual Albertan can see all of the information about them and make sure that it is being used correctly. And if they believe it is being used incorrectly, they can file a complaint and have that looked at right away.
Thank you.
Thank you.
Sure. Catherine Gurkowski, Alberta Today. So I'm hoping you can clarify. So public bodies can no longer sell information, but they can give this de-identified or non-personal information. Can it then be commercialized? Can you explain what the guardrails are in terms of sharing with other bodies?
Yeah, so let me be perfectly clear. The government does not today sell information. Public bodies do not today sell personal information, and we never will. It was important to me to codify that into law so that Albertans knew for sure that no government ever could and no government ever will sell their information. In terms of the de-identified, anonymized records, it was important for us to be able to say, look, sometimes we're going to need to bring in a technological expert to help us develop new technology tools to develop better services that can deliver services to Albertans in a modern way, in a more technologically advanced way, so we can give them a better experience. And in order to do that, we need to be able to say, well, if I'm bringing someone from the outside to help us build something, I don't want them to have personalized information. They shouldn't have access to personalized information. So we needed to create definitions around these new terms of what does de-identification even mean? This legislation brings those definitions forward so that we know exactly what is non-personalized information and what are the protocols for de-identification. We have no intention of that information leaving our care and custody. It is our job to safeguard that information. And as we look to find ways to bring in technological partners to develop better tools and technologies to better serve Albertans, we will carefully select those. And the details around how the de-identified information can be used will all be spelled out in regulation as per the Act.
Okay. And my follow-up is to Minister Nally. You said FOIP is about access to government records, not access to political conversations. I mean, FOIP already has exemptions in the Act to protect advice to cabinet, but this seems like it goes way further. I mean, political conversations are what shape policy. Why does the public not have a right to know about those?
This isn't changing anything. This is the way it is today. This is just providing clarity. And as I said, political staff exist today as they will tomorrow. This is about the public's right to access government records. And if it's a political conversation, then that's not going to apply. If there's a department official that's on the email, then that could then would fall under FOIP. But if it's just a political conversation, that does not constitute a government record.
I apologize. We're just going to go to the phones. Operator, can you please put through the first caller?
The first caller is Madeline Cummings from the CBC. Please go ahead.
Hi there. My questions are for Mr. Nally. Bill 34 would extend the use of the advice to officials exemption to cover background factual information. Given that other provinces' legislation, including BC and Ontario, specifically says factual information can be released, why would doing this enhance Alberta's freedom to access information? Because it seems like it's just placing another limit on it.
So Every jurisdiction is a little bit different, but what we have in common is that all of our FOIP legislation is about the public's ability to access government records, and it's defined a little bit differently in every province, for sure. In our case, we have simply brought this forward so that we could provide clarity that is already there.
Bill 34 also says public bodies. Yes, sorry. Bill 34 also says public bodies could get time extensions during emergencies or disasters. Sometimes the public appetite for information about how the government is responding is in fact heightened during the crisis. So why should Albertans not have timely access to information during these times?
If Jasper, heaven forbid, were to be under another emergency like they just had, or Fort McMurray, the priority will always be dealing with the emergency at hand. Always. And this is just clarifying that.
Thank you, operator. Can we get the next caller, please?
The next caller is Tom Cardoso from Global Mail. Please go ahead.
Yes, Tom Cardoso from the Global Mail here. My first question is for Minister Nally. The Global Mail has twice requested freedom of information data from Alberta's ministries and been twice denied. Eventually, the OIPC launched a systemic investigation into the Alberta government's handling of those requests, which I understand is ongoing. With these changes, will the government release this kind of data?
So what I can say is that any matters that are currently being investigated by the OIPC, we're not going to comment on. But moving forward, we believe that this legislation will provide the clarity to hopefully avoid these types of situations.
Thanks. And just a follow-up on the exemptions, the new exemptions being written into Bill 34. Quite simply, why are political staff being written out of the law?
So first of all, these exemptions are not new. We are just simply clarifying what has already been the case. Political staff have always been exempt. It just hasn't been clear in the legislation. So we're putting forward the amendments to articulate that clarity. Because again, Albertans want and should have access to government records, but not necessarily political conversations.
Operator, can we move to the next question, please?
Thank you.
Next question, operator, please.
The next question is from Jason Markisoff from CBC. Please go ahead.
Thank you. This is for Mr. Nally. What sort of, can you give me examples of any proactive disclosure you would like to see the government of Alberta undertake?
Thank you for Jason. Thank you for the question. I'm excited by this because this is the best part about Bill 34 is the proactive disclosure. And I say that because we know that there are certain things that Albertans are just going to request. And it'll be different for every public body. But if we know the request is coming, why are we going to make Albertans pay $25 or $50 to request it? Why are we going to make them wait $30 for an answer? Let's proactively disclose that information, and it's just one way to make life better for Albertans. Now, we currently do it with things like expenses and sole source contracts. So we're going to go back, and when we do the regulations, we're going to consult with stakeholders and find out where does those proactive disclosures need to be. We're going to define the process, but we're very excited about this because this is going to promote openness and transparency in government.
I asked you for examples of them, and you can provide them. But let me ask my second question. How has, you were talking about the focusing with governance and frank and robust discussions. How has this been impeded by not explicitly blanketing or shielding political staff from the regulations?
Well, what has been lacking has been the modernization and the clarity. And again, as I said before, this legislation currently predates the commercialization of the internet. It was at a time when we could not have foreseen the digital evolution. We could not have foreseen social media and cloud computing. So we needed to modernize the legislation. And then in addition to that, we just needed to add the clarity so that it's clear to all Albertans what information they have access to.
Thank you very much. Operator, do we have any more callers on the line?
There are no further questions at this time. Please proceed.
Okay, we are running short on time. I'm going to allow for one more question.
Hi, Janet French again from the CBC. Okay, so one of the main groups that file FOIP requests, or I guess ATIA requests now, if this passes, are the opposition. So go with me on a journey. It's 2028, Premier Naheed Nenshi and his NDP government are in power. You are now in opposition, and you're the one filing information requests to try and get information about what's going on, what reports the NDP government had before it when it made those decisions, and you're getting stonewalled because of this law. Is this scenario acceptable to you? And if, why or why not?
Well, first of all, let's hope that nightmare scenario that you just described doesn't come to be. But if it does, the rules that will apply to us, that apply to the opposition today, is at the end of the day, whether you are a political party that's in opposition or another Albertan, you have access, the right to access government records. And what this legislation does is it ensures that you have that access. It modernizes the Act to make it clear that it includes things such as social media and other digital applications. And it also provides clarity, so Albertans will know exactly what information they'll have access to. So I don't think stonewalling will be a thing. I think this will help enhance transparency by providing the clarity to what information is available.
Just to clarify, you're perfectly comfortable with this applying to an NDP government and you being in opposition?
Well, again, I hope that situation doesn't come to be, so I'm not comfortable with that. But I am comfortable that we are putting in the amendments that don't forget, the Supreme Court of Canada ruled that these type of amendments are what is part of good governance. And so that's what we're providing here is good governance and supported by the Supreme Court. So we're very comfortable with that. But in addition, by going that next step and putting forward a process for proactive disclosures, that's the piece that is really going to make life better for Albertans. It's going to promote openness and transparency in all public bodies, and I absolutely support that.
Okay, thank you. That concludes this news conference. If you have any further questions, press secretaries' names are listed on the news releases. Please feel free to reach out at any time. Thank you very much.